Hello, everyone, and welcome to Uncivil Law. My name is Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we are going to review an ongoing issue involving Nick Rekieta. Nick Rekieta, who used to be a lawyer, had his home searched for drugs. Drugs were found, as you will recall, and he eventually pled guilty to felony possession of those drugs, although the actual judgment of guilt was deferred, suspended, pending probation. So he is not convicted at this time, although he has pled guilty. He is also simultaneously fighting an issue where people would like to see the body cam footage and presumably other footage, such as dash cam footage that might exist from the incident at his house. The footage has not been made available, although a couple people have seen it by actually going down to the courthouse and actually looking at it before it was sealed even from that. So a few people were able to see it in person by going to the courthouse, but it has not been made publicly available. Under the relevant law, as I understand it, unless the information was offered as evidence, the information can be and generally is withheld unless it's deemed to be in the public interest to reveal it. And this has been the contention, that it's in the public interest to reveal it. And by Mr. Matthew Hardin, who has sued to have the information revealed. So what we're going to do today is review Mr. Hardin's brief. Then we're going to also review the state of Minnesota's brief, as well as Nick Rekieta's brief, and try to analyze who has the better end of the legal issue in play. Whose end of it is better legally. So we're going to read all three and try to offer a legal opinion, because that's how we roll. We will start with the intervener, the person who would like to see the footage very much, and their brief and what they have to say about the operative legal issues that are in play. The legal issue: whether Mr. Hardin, or presumably anyone else for that matter, is entitled to view records submitted by Nicholas Rekieta and referenced in his brief in district court pursuant to Constitution or common law right of access. So there was this issue because it had been filed by, I'm going to get this slightly wrong, and I'm sure the brief will clarify it, but I think it had been put on docket or filed by Mr. Rekieta's lawyer, but not actually referred to in any way, which means it doesn't really count. So it was, I think, entered onto the docket by Rekieta's lawyer, I'm pretty sure, as part of the motion to suppress. So I think Rekieta's lawyer is the one who submitted it to the docket, and then, but he didn't actually refer to it in any way in any of his briefings, which just says how I think it got on the docket. 1999 from Nate the lawyer. Let's effing go. I'm glad to report that Nate the lawyer is back home, by the way, for those of you who are concerned by his health. So he is back home with his family, and I look forward to seeing him tomorrow to catch up with some more. And we're going to have a stream pretty soon in which we are going to recount the story of what happened. And I'm going to be there because Nate isn't necessarily a reliable narrator for all this, but I am, because I was there. Nate was less there at the time, but we'll discuss that later. But thank you, Nate, for the 1999. It's very kind. In any event, yeah, Nick Rekieta's lawyer put it on the docket, but then didn't refer to it. And so he's like, that didn't count. So that's sort of the issue again, apparently. Anyways, pursuant to the Constitution or common law right of access, presumably the Constitution of the state, but we'll see. Trial order held, whatever. Mr. Hardin preserved the issue written by motion. So the trial court already ruled on this, and they're like, not so much. Whether Mr. Hardin is entitled to be heard and present evidence before the trial court to make adverse factual findings which affect his substantial rights. Trial court held Mr. Hardin's written motion to intervene was granted in pertinent part, while trial court held that no further briefing is required, which, you know, kind of makes sense because it's a pure limited issue of law, right? There's no particular reason to allow anything more because it's just pure legal issues. And so the court's like, well, I'm going to rule on it based on what I know. So I'm like, okay, fair enough. This effectively denied the relief he sought filed in the written motion. Yeah, so the court just basically denied him, granted him limited permission to intervene, but said there was no briefing or hearing required. So I grant your petition to appear and I deny your request, which gives him grounds to appeal. Fair enough. Here are a statement of the facts, at least as they're going to be presented by this brief. Nicholas Rekieta filed a motion to dismiss his criminal case on August the 18th. In that motion, He cited 2 body cameras he believes support his argument, one from Candy, High Sheriff Deputy Barnes and one from Deputy Poplin. Both these were filed with the court via the representative system contemporaneously with the motion. I'm not sure, strictly speaking, that he cited the videos is correct, but he did file them on the docket. That's true, which seems like a cell phone, but whatever. The trial court held a hearing on the motion to dismiss and denied that motion. Motion to dismiss and denied the motion, right. On April the 12th of 2025, Mr. Hardin filed a Minnesota Judicial Branch copy request form, which we requested evidence submitted through the system by Nicholas Rekieta, including but not limited to the 2 files that Nicholas Rekieta's own lawyers put on the docket, which is just kind of hilarious, right? His own lawyers are the ones that filed it. So this entire situation is being created by a cell phone. So if this gets released, it's because Nicholas Rekieta wanted it released because he's the one that filed it. So, there's that. So the irony could be very thick, my friends. Oh my God, it's my unintended consequences again. The unintended results of my actions are coming back to plague me once again. What are the odds? Good times. On May the 1st of 2025, the Candy, Ohio District Court approved Mr. Hardin's request for access to the record. Specifically, the court noted it reviewed the evidence and was aware of the contents of the evidence, stating that 2 body cameras exhibits request to display unredacted displays of children who were present during the search warrant, along with viewing all rooms and spaces. We're perfectly comfortable having the children, blotted out if that's the issue. I'm pretty sure Mr. Hardin would be also happy to have the children's images, blurred out or whatever. I don't think that's the issue, okay. But again, even if it is the issue, it's Nicholas Rekieta who did it, right? Nicholas Rekieta is the one who filed the body camera footage, including his children as they appeared on the footage. So it's like, if his children are seen, it's because Mr. Rekieta put his children's images on the file. Yeah, that's okay. So that's the stupid continues to burn. Due to what the court deemed the sensitive nature of the contents of the footage, the court allowed Mr. Hardin to view the evidence in person rather than view the evidence remotely, as I believe other people did as well. Without any notice to Mr. Hardin or any opportunity to be heard, and apparently in an intentional effort to circumvent a Minnesota Government Data Protection Act requested by Mr. Hardin with the Candy, Ohio County Sheriff, the Candy, Ohio County Attorney filed a purported consent motion in which the county attorney and criminal defendant asserted for the first time the evidence submitted via the system and cited was not actually admitted into evidence, which I don't believe it was, to be fair. It wasn't actually admitted into evidence. That's actually a step you have to take. Other than just dumping it on the docket. Those aren't quite the same thing, right? To actually admit it into evidence, you have to go through a procedure in court to have it admitted into evidence. So it was available, it was on the docket, it was shared, but that's not quite the same thing as it being in evidence. So, I agree it wasn't in evidence, at least as far as I understand the operative law in the state. That's true. Mere minutes after the courthouse opened, the trial court granted the consent motion without providing Mr. Hardin any opportunity to be heard, which I don't know how Mr. Hardin would have any information on this issue. It's, again, there's nothing Mr. Hardin could add to this equation, right? All the available information is known, and there's nothing Mr. Hardin can add to this, right? How it got to be on the docket, who did it, how it was submitted, whether it was or was not evidence. There's nothing Mr. Hardin can add to this picture. He has no information to add. So, fair enough. Immediately upon being aware of the county's motion through checking on the public docket, not because he was served, which it wasn't about him. So, okay. Mr. Hardin sought leave to intervene in the criminal case for the purpose of preserving access he had been previously granted to the evidence at issue. So maybe he never got to see it. Maybe he didn't get down to the courthouse in time. But I understand other people did. Specifically, in Mr. Hardin's motion to intervene, he requested two forms of relief. First, that Mr. Hardin be permitted to intervene for the purpose of filing the motion to vacate the order they conclusively obtained without notice. I'm not sure he's entitled to notice, to be honest. Second, that Mr. Hardin be permitted to file a brief in opposition to consent motion, which I don't think that makes sense either as an intervener, and present evidence and argument in opposition to consent motion. On June the 16th of 2025, the trial court entered ocean which purported to grant the limited request for intervention. However, the trial court made 16 separate enumerated finding of facts without participation. Because again, I'm not really sure Mr. Hardin really has any information to offer on this issue. What facts could Mr. Hardin offer that would be relevant to this? He doesn't have anything to offer, right? I mean, everything he knows, he only knows from the court docket, which he doesn't have any special information. He doesn't have access to any special information. He has nothing to offer. He has legal arguments, potentially, but he doesn't have anything factually to offer this picture. So, I mean, it just is what it is. And the trial court stated it would not allow further briefing because as far as the trial court's concerned, I don't need to hear from him because he has nothing to offer. In this case, the criminal defendant submitted certain body cam footage through the system in support of a motion to dismiss and cited extensively to the body camera footage in brief. Did he, though? I don't really remember that he did. I don't remember citation to the body cam footage. I don't remember that. After the motion to dismiss was denied, Mr. Hardin requested access to the footage. The trial court initially granted Mr. Hardin's request in pertinent part and issued a written opinion in which the district judge expressly noted the content of the body cam footage, confirming the court had indeed watched it. The trial court quickly reversed itself inexplicably when the criminal defendant in the underlying case and Crown Attorney rushed to court without notifying, seeking correction of the record in a way that would circumvent the request for access. Well, that's because, as I understand it, by this time, other people had seen the footage. So other people actually took the time to go down and see it and had been reporting on the footage with fairly detailed notes in some cases. So they were aware that people could see it and people had seen it, and they essentially wanted to seal it so no one could see it. So it wasn't Mr. Hardin's motion that really tipped them off. It was the other people reporting on it on Kiwi farms, among other places. So, all that. Without notifying Hardin, seeking correction of record in a way that would circumvent the request for access and related Government Data Protection Act request. Yes, in response to a motion presented by Kandiyohi County with apparent consent of the criminal defendant, the court suddenly revoked Mr. Hardin's access that had previously viewed and issued written findings explaining. Fair enough. I mean, because the court changed the legal posture based on new evidence. Let's see. Remarkably, the court now held it had not reviewed the records at all. Mr. Hardin laterally formally moved to intervene in the criminal case for limited purposes seeking access to court records, specifically noted that he sought leave to file a brief in opposition to consent and set a hearing at which he, Mr. Hardin, can present evidence and argument regarding his rights to access. The trial court purported to grant Mr. Hardin's motion to intervene in the criminal case in a limited extent, but the trial court did not allow him to file a brief nor did it set a hearing. Instead, the trial court made 16 separated facts, all of which afforded Mr. Hardin any opportunity to participate or challenge. I don't know that he could. The trial court then denied Mr. Hardin access to the records, which is a pure legal conclusion. This is error for two reasons. First, the records are plainly judicial records, and the court's own May the 1st, 2025 order demonstrates the court had viewed such records and made findings as to the content of such records. Okay. Second, the trial court was not permitted to make factual findings adverse to Mr. Hardin without permitting Mr. Hardin an opportunity to be heard. Why not? It was a limited motion to intervene. He has no rights in the first instance, and the court basically is granting a limited intervention. And so the nature of the intervention is kind of what the court wants at that point, because he's not a party to this. He's not a party to it. He's trying to get at it a different way. So, okay. Especially when the trial court purported to have granted Mr. Hardin limited status as an intervening party. Yes, but the nature of the limited status is kind of the issue. The standard of review, whether a record is a judicial document, which is open to the public inspection under a constitutional or common law right of access, is a pure question of law subject to de novo review. Um, well, for the most part, yes. I mean, yeah, it is pretty much a pure question of law at this point because the factual predicate is understood. So there are no facts disputes. There are no factual disputes. So at this point, yes, it's a pure question of law. What else would it be? Unless you could somehow say you could challenge the trial court's findings of fact, but how could you do that? And how would that even make sense? And what finding of fact do you think they got wrong or left out? Like, what is the material aspect of this? He hasn't said yet, by the way. He's just said, you deny me the chance to participate. But why did that matter? Why did his ability to participate matter? What would have changed? What is the error? What is the materiality of the error? It's unclear yet. Okay. What difference would it have made? Whether the trial court has denied a party opportunity to develop its evidence, what evidence? The court cannot uphold the trial court's judgment and should demand for further review of what? What possible other evidence could you offer? If he doesn't at some point in this brief tell me what evidence he wants to have offered, if he doesn't tell me what it is and why it's mattered, I'm going to be really, really grumpy. And so will the Court of Appeals. You should have given me a chance to present evidence. Why? What would it have been? What would it have mattered? Why do we care? Hopefully at some point he'll tell me. Okay. And then we cite some case remanding to a trial court so a state could develop a factual record when it was not previously required to develop. I mean, there are certainly times when that's true. I don't know why it's true here. Another case holding that although appellate courts do not ordinarily consider arguments not presented at trial, exceptions can be made. That's true. It can be done. But why here? Alternatively, this court might view the trial court's denial of an opportunity to be heard, including but not limited to the opportunity to present proffered evidence, like what, as a violation of procedural due process. How do you have procedural due process as a limited intervener? In which case, the denial will be subject to de novo review. Okay. That's your argument? That seems like a strange argument. Because you're kind of trying to do on factual issues. That seems like the wrong line of argument. Right? That feels like the wrong line of argument for this appeal. If I were going to fight this appeal, I'd just be going on the pure legal issue, right? I'll just take all the facts as given and just say, well, given all those facts, I should be entitled to view the thing, because that's the legal argument. Now, I don't know whether or not I can win on that ground, but I don't see how I'm going to win on the factual issue because I don't have any facts to offer. What facts do I have to offer? What do I know? What testimony could I give? What evidence could I give? Right? I mean, there's nothing to do, right? The evidence is what it is, right? I mean, that it was submitted to the filing system on a certain date with these file names at this time. It was submitted by Nicholas Requeda's lawyer. The court wrote in its opinion what it wrote, either did or did not cite it. Either that did or did not happen. Either it did or it said it considered or it didn't, right? I'd just be quoting straight from the record. That's what I'd be doing. I'd be like, look, here's clearly where the court cited it. Let me cite you the places the court cited it. Let me show you all the places they cited it. Let me show you the place the court said it considered it. Let me show you these things. And that's why I win. If I have the cards. If I don't have the cards, then I'm just making shit up. Right? So I hope he has the cards because he says he does, but he hasn't shown me yet. So and even then, it's not based on any facts he has to offer. It's not like he has some unique testimony. His entire argument would just be, go read the fucking page. Just go read the goddamn page. Go read the court order. That's how I did it. I read it. You can too. Go read it. Go read page 5, line 6, where it says da 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 da. Don't take my word for it. Go read it. It's in a book. Take a look. Reading Rainbow. But he has no. Okay. Argument: Mr. Harm was entitled to view the records he requested, in which the court previously ordered he could review. You do understand that courts generally have the power to change their own orders, right? It's not like you have property right in it. It's like, oh, the court said I could view it, and now I have a property right they can't take back. And that's not how that works. The records Mr. Harn requested reviewed were submitted to the court via the criminal defendant and cited by that defendant repeatedly in the motion to dismiss. Was it cited? I don't remember the citations. See, you don't have to just tell me, just show me. Show, don't tell. Show, don't tell. Don't tell me he cited it, show me. Say, on page X of motion Y, it said in line Z, dot, 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 dot. Just show me. Show me the Carfax. The motion to dismiss was denied, and Mr. Recato ultimately entered a plea of guilty. He sure did. The court unquestionably viewed the video footage submitted by the defendant because the court's initial order granting the motion access to records explained the substantive content of the video. Well, just quote it. Just quote the words of the court. Just quote it. I'm getting frustrated. The records are therefore inarguably judicial records, and there's a presumption of public access to those records stemming from at least three sources: the United States and Minnesota Constitution and common law. Please note, by the way, he doesn't actually cite anything. It's in the U.S. Constitution. Where? Where in the Where in the Constitution is it? Would you like to cite an article, a section, a clause, an amendment? No. Where in the Minnesota Constitution is it? Would you like to cite any particular portion of the Minnesota Constitution? Oh, it's just in the Constitution, somewhere, floating around in the ether. Great. That's great. That's fantastic. It's in the common law. Would you like to narrow that down at all? Would you like to narrow that down from like the 800 years of common law? Would you like to tell me where? No, you wouldn't like to tell me? Oh, okay. It's just in there somewhere. Take my word for it, bro. Sure. Oh, Lord. The presumption of access has not been rebutted, and a trial court only claimed the records were never judicial records to begin with. That was error. First, the court must determine whether the records Mr. Harden requested are judicial records. According to the trial court, the answer is no. This was error. Sure. There's a common law access to judicial records. I'm getting really pissed. I'm actually getting pissed at this point in this brief. I'm getting mad. Okay. He's like, they're judicial records. He doesn't say why they're judicial records. His next sentence is, there's a right of access to judicial records. Well, that presupposes they are judicial records. You can't say these are judicial records and then say, well, there's a common law right of access to judicial records. You kind of have to prove they're judicial records first. Why are they judicial records? Talking about your right to access the records because they're judicial records, you haven't proven the predicate yet. You're killing me. I'm dying. But the common law is not the only source of this right. The Constitution, both Minnesota and the United States, provide access, to which he's still not going to tell me where in the Constitution of either one, incidentally. As the Eighth Circuit explained, the right of access bolsters public confidence in the judicial system by allowing citizens to evaluate the reasonableness and fairness. The status of a document as a judicial record depends on whether or not a document's been filed with the court. Well, finally, he's fucking citing something. Jesus Christ. The status of a document as a judicial record depends on whether a document has been filed with the court or otherwise somehow incorporated or integrate into a district court's adjudicatory proceedings. Citing Third Circuit. We're trying to determine whether they're court records for the purpose of Minnesota state law, right? So while I appreciate your Third Circuit citation, better would have been a citation from, the Minnesota Supreme Court. That would have been better. If I'm trying to determine what Minnesota law is and whether or not these are Minnesota judicial records, who'd be a really good authority on that? the Minnesota Supreme Court. So while I appreciate your Third Circuit site, you got anything better? As the Eighth Circuit noted, oh wait, no, that's the wrong part. All documents properly filed by a litigant seeking judicial decision are judicial records entitled to presumption, citing a district court of Minnesota. This brief sucks. This brief is sad. The mere act of filing a document with the court clearly establishes a document is a judicial record, but even where a document is not filed, it may still be a judicial record if the court interprets or enforces the terms of that document or requires that it be submitted to the court under seal. Why? Why are we writing these things? Why are we writing these things? Did we just start throwing darts at the Federal Reporter and we're just like citing, whatever pages we happen to hit? This, you're not really selling me, man. You're not really selling me on this, I have to say. Not feeling that. There's a presumptive right of public access to pretrial motions of non-discovery nature, which this isn't, by the way, whether preliminary, dispositive, and material in the field of contextions thereof. Some more Third Circuit opinions. I'm going to be sick. Here, the criminal defendant, and arguably, wait, is Minnesota even in the Third Circuit? I have to check my map. I have to check my map. Hold on. Is Minnesota even in the Third Circuit? Hold on. No, it's in the Eighth Circuit. Well, that's great. So not only are you citing cases from not only are you citing cases that are not from the Minnesota Supreme Court, you're not even citing cases from the controlling circuit for this state. Okay. Great. That's super great. That's just fantastic. Super well done. That's great. That's really great. Here, the criminal defendant inarguably filed certain evidence accompanying his motion to dismiss, which apparently believed would support that motion. The evidence was submitted was video footage and was so naturally not attached to the motion as exhibit might otherwise have been, but instead filed and served via the whatever system. Regardless how, the court required the material to be submitted, and the criminal defendant's brief cannot be fairly read or understood if the material to which its public site is unavailable. Yes, it can. I read it and understood it without reference to the material. I both read it and completely understood it without reference to the material. I don't even remember Nick Rekieta citing the footage anywhere in his motion. I don't remember that. And it seems like our applicant over here doesn't remember that either, because you know what would be really helpful? What would be really great is if he started citing it. He's like, oh, it was in the motion to dismiss brief, silly Uncivil. It was in the motion to dismiss brief on page 7 at line 4. He clearly said, as shown in the body cam footage, here and attached, blah, 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 blah. I was like, oh, now I remember. Now I remember him saying it, but not so much. He's not saying that. I'm pretty sure because it didn't happen. Yeah. But he wants me to believe it did. Okay, that's great. It's going great. All right. Regardless, however, the court required the material to be submitted, and the criminal defendant's brief cannot be fairly read or understood if the material to which its public site is unavailable. If the material cited in the brief were somehow not part of the brief itself, which it's not, the evidence Mr. Rekieta submitted to the court was clearly filed in connection with his underlying motion within the meaning of this case, which isn't even a case from the relevant circuit. Further, unlike unfiled documents such as discovery requests, the court actually viewed the thing. You're gonna actually okay. The trial court candidly conceded that the M's relevant to the performance of judicial function are judicial documents. Yeah. The criminal defendant certainly thought the two body camera footage issues were relevant for the purpose of judicial function. Well, I don't know about that necessarily, but okay. Because he cited those videos repeatedly in arguing that all charges be dismissed. Then CEG, Mr. Cada makes 6 separate citations to 2 items of evidence in support of his motions to dismiss his hearsay. You know what I would have done? I would have just actually listed all 6. If he really made, this is the backbone of your case. This is the backbone of your case. If you really believe 6 times he cited the body cam footage, you bet your ass I would put all 6 in the brief itself, because it's the cornerstone of my case, right? He cited it 6 times, Your Honor. Here's all 6, and the court cited. Here's where they cited. Said we consider. I cite it all. You better bet your ass. Several times I'd probably cite it. But not so much, man. Not so much. Yeah, it's not going great. It was error for the trial court to somehow determine, after receiving the criminal defendant's briefing signed to the evidence, and after inarguably watching the relevant footage, which just quote the court if that's what happened, and commenting on its content, the records at issue were somehow not judicial records, or therefore not presumptively public. Because the records at issue are judicial records, which you haven't convinced me of in any respect, a presumption of public access applies. That presumption may be occasionally rebutted. Federal courts in the District of Minnesota have utilized a 6-factor balancing test for the purposes of their own records or for the purposes of federal constitutional law, because that matters. Right? When the federal courts say, hey, records can be restricted, and here's a 6-part test, are the federal courts saying that for the purposes of federal records and federal law, or are they saying it for the purpose of the U.S. Constitution? Because if they're only saying it for the purposes of like the statutory law, then fuck whatever, right? I mean, then, the federal courts are determining access to their own records. And for the purposes of determining access to their own records, they've got an exciting 6-part test. But unless that exciting 6-part test derives from the Constitution of the United States, guess what impact it has on Minnesota? Fuck all. Fuck all would be the answer. So, did you know that? Did the person writing this brief know that? I don't think they did. I think they thought, federal court says something, therefore it must apply to Minnesota. That's not how it works. Okay, and then for this proposition, just to continue pissing me off, he cites the DC Circuit, which is also not the 8th Circuit. So not only is it, probably about federal records and the standards that apply to federal records, it's once again not from this circuit. But that's okay. He has an unreported case from a district case in Minnesota, which cites this thing for some proposition, something World Star. Okay. Who wrote this brief? Why did they write this brief? This brief horrible. Okay. Oh, finally, he's going to cite the 6 factors. Oh, thank God. Not that it matters, because it's from the wrong circuit and probably doesn't concern this anyway, but he's going to cite the 6 factors. The 6 factors a court can use to evaluate can use? Oh, it's optional? Oh, okay. Can use whether presumption public access has been rebutted are the need for public access, the extent of previous public access, the fact that someone's objected to the identity, the strength of any property and privacy interest, the possibility of prejudice, and the purpose for which the document, citing again that district court case, which itself was citing the DC Circuit. Okay, here the district court did not apply the factors at all, probably because it's not binding authority. That's probably one of the reasons they didn't apply the factors. One of the reasons they didn't apply the factors is because they didn't have to. Because it's from the DC Circuit. And they're not DC now, are they? No, not so much, no. Here, the district court did not apply some bullshit law that didn't apply to them anyway, possibly because that court proceeded to adjudicate Mr. Hardin's entire claim without the benefit of briefing, and possibly because that court's earlier error in determining the records at issue were not judicial records at all, which you still haven't convinced me of in any respect. Regardless, the Hubbard factors weigh in favor of public access. If only the Hubbard factors mattered. If only the Hubbard factors actually were like legally applicable in this situation, or had anything to do with the price of tea in China, that would be great. But not so much. No. First, there's a need. He's going to continue discussing it like it's dispositive. He's going to walk us through all 6 factors and why they do or do not apply, like it's controlling. I hate whoever wrote this brief. Was this pro se? It better have been. This better have been a pro se brief. I swear, if an attorney filed this, I'm going to punch somebody in the face. First, there's a need for public access to documents at issue in order to understand the criminal defendant's briefing, which argued his substantial rights were violated as police officers committed serious misconduct. What the fuck? Specifically, the criminal defendant argued the 2 officers had violated a third-party Miranda rights after the party expressly requested an attorney. If the state were to attempt to present evidence in violation of Miranda, that could be prosecutorial misconduct. What the fuck? The state said explicitly that they weren't going to use the statements against, what's the whore's name? What's her name? I forget. I want to say Ashley, but that doesn't sound right. Against the whore. So yeah, they said they wouldn't use the information, so it's fine. April, thank you. I knew it was an April. I couldn't quite come up with it. April, thank you. Yeah, they said they wouldn't use it against April, so no problem. It's fine. So this is speculative, and also the state itself said it wouldn't have done this anyway. Civil litigation is also a possible consequence. Miranda rights are violated. Yeah, hypothetically, but not really so much here, no. It's impossible to understand Mr. Cade's argument, and whether he's correct that the deputies violated Miranda, which doesn't matter because they weren't his Miranda rights anyway. It has nothing to do with him. And they weren't using the evidence at that point anyway. It might be a confrontation clause issue way down the road, but he has no standing to raise the Miranda issue because it's not his rights. He has no Miranda rights relative to April. It's not a thing. He has confrontation rights, but that's at a trial way down the road. For the purposes, incidentally, of like an indictment or something like it might be able to be used. I mean, I'd have to get into the finer points of analysis of that. I actually don't know the answer to the question off the top of my head, whether or not you can use like statements obtained in violation of Miranda for the purposes of like a probable cause finding. You might be able to. I honestly don't know the answer off the top of my head. But in any event, it doesn't matter because it wasn't material to anything. So like, whatever. Second, the documents at issue in this case were previously made open for public access. The court later determined that was an error, sought to correct. Yeah, that's what happened. That's correct. That's correct. It was deemed public access, and the court was like, "Oh no, it shouldn't have been," and then changed its mind. Yeah, just because it made a mistake doesn't mean it's bound by that mistake forever. That's not at all how that works. If a court makes a mistake, they're allowed to reverse themselves. Didn't you know that? Trial courts reverse themselves. Good trial courts do it with some frequency because good trial courts realize they're human and make mistakes. So like, yeah, this is the weirdest version of I had ongoing rights because I had expected property or something. This is a very weird established interest thing. Like, I had an ongoing interest and they took my interest away. I'm not buying any of this shit. Regardless, as a result of Mr. Harn's original request for public access, at least 2 individuals were able to visit the courthouse and view the video footage. That's true. That's correct. That's what I understand. Unfortunately, Mr. Harn himself was not able to travel to Minnesota and view the footage himself before his access was revoked. Well, that's unfortunate. Previous public access to documents weighs in favor of future access. After all, once documents have been made public, sealing those documents or removing the access to ability cannot unring the bell. Well, it can to some degree when by public access, they meant you had to come down and view it in person. They were never released in the sense of being able to be viewed, by people on the web. Yes, 2 or maybe 3 people went down there in person and viewed it in person. It's relatively easy to claw that back. All we have to do is say no one else can come in and view it anymore. And so those 2 or 3 people have seen it, which, is 2 or 3 more people than, was ideal. But, it's not like now we have to let everyone see it forever, right? If I make a mistake and let, 3 people violate the law, do I have to continue allowing people to violate the law because I allowed these 3 people to? Right? This makes no sense. This makes no sense. Right? Let's suppose I'm a bouncer at a nightclub and I let 3 people through the door, and then my boss comes up to me and says, "Hey, wait a second. We told you no more people through the door. We said, we're at capacity. The fire marshal's on their way, man. We're at capacity. Those 3 people put us over capacity, man. The fire marshal's on our way. We're going to get fined." I'm like, "Oh my God, boss, I'm so sorry. I'm so sorry. Somehow I didn't get that communication. I'm really sad." And the next person is in line saying, "You let those 3 people through." And I'm like, "Yeah, but I wasn't supposed to." "But you did. I'm entitled to go in too." Does this make any sense to anybody? Of course not. It doesn't make any sense. This is really dumb, right? I let 3 people park in the handicap space, even though they don't have handicap placards. It's like, yeah, that's a free space. Go ahead and park there. And then the guys, then the people are like going to get tickets, and they blame me. And the cop comes up to me. "Did you tell them you could park in a handicap space?" Like, oh my God, I forgot. Despite the clear and obvious markings that somehow I missed, right? I forgot. Well, don't fucking do it again. You need to let me park in the handicap space. You let those other people. This is all sorts of dumb, right? After all, once documents have been made public, sealing those documents and removing their accessibility cannot unring a bell. It can a little bit in this situation. Third, the trial court should have considered whether any party objected the identity of the party. Here, the state and criminal defendant joined together without notice to correct the trial court record. It made clear the objection to disclosure. Because you don't have anything to add to the party. The irony of a criminal defendant and its prosecutor agreeing that evidence should be kept secret should not be lost in the court. There's no irony in that. There's no irony. What the fuck are you talking about? The prosecutor and defendant agreeing that certain evidence shouldn't be made public? That's not ironic. It happens all the time. All the time. There's all kinds of evidence that the police capture and the prosecution doesn't want to offer as evidence, and neither does the defense. It's ironic because the defense and prosecutor agree this shouldn't be made into evidence. If that's ironic, then ironies are occurring literally every day, all the time, constantly. So I don't know about that. The Minnesota Supreme Court and the U.S. Supreme Court both agree the need for public access to evidence is particularly strong. Citing a case that cites the U.S. Supreme Court. Okay. The crucial prophylactic aspects of the administration of justice cannot function in the dark. No community catharsis can occur if justice is done in any corner or any covert manner. This brief makes me sad. And makes me want to drink. In a criminal case, the community must have the ability to understand the truth, including whether a criminal defendant's very serious allegations of governmental wrongdoing are true or not. The video footage at issue will serve this exact prophylactic purpose. Fourth, the court must consider, not really, because even you earlier said may. You said they may, not must, and now you're going back to must, so you can't even decide. And also, it's not from the right circuit. First, this court must consider the strength of any property or privacy interest. Here, to be sure, the trial court recognized some privacy interests. Specifically, the trial court commented the footage the criminal defendant had filed with the court showed the interior of the home in which the search warrant was executed and certain minor children present at the time were executed. Which, incidentally, the court might know that without actually reviewing the underlying materials. Because maybe someone told them. Just because the court knows that doesn't mean it viewed it. Only the most compelling reasons can justify non-disclosure of judicial records. Even then, however, the remedy is not wholesale withholding entire documents or records. Even where a party can show compelling reasons while certain documents or portions should be sealed, the seal itself must be narrowly tailored. And it's not enough for a party to simply point to privacy concerns in a general manner and demand sealing. That's not what they're doing. They're not trying to seal it. They're trying to say it was never public in the first place. That's not quite the same thing. Fifth, this court must consider, and there's that word must again, the possibility of prejudice to those opposing the disclosure. Here, there's no possibility of prejudice because the criminal defendant has already entered a guilty plea after his motion to dismiss was denied, and the time for any appeal has passed. It therefore matters not where the evidence he submitted becomes public, because no jury can possibly be influenced by the evidence it alleges the police obtained improperly. Indeed, if the criminal defendant is correct, the evidence demonstrates police misconduct. Release of the footage may benefit him as the public rises up to demand reform and redress. Sure. Sixth, the court must consider the purposes for which the records were introduced. Here, the criminal defendant itself submitted the evidence at issue because it believed it would show police misconduct and result in the dismissal of very serious felony charges. The defendant thus invoked judicial powers to seek a remedy, and the trial court exercises power to adjudicate the dispute. Not by reference to the video cam foot. I'm struggling. I have not read Nick Recada's motion in a hot minute. It's been a while since I've read Nick Recada's motion to dismiss. And it's been a while since I read any of the court documents, but I'm struggling, man. I'm struggling. I cannot, for the life of me, remember in his motion to dismiss him like citing the camera footage, and I can't remember any of that. I can't remember the trial court in its decision referring to the video. I don't remember any of that. And he's not citing it to me. He just said, trust me, bro, at one point. He said, trust me, bro, it happened a lot of times. Could you cite it for me? Could you quote it for me? Could you refresh the recollection of the poor Uncivil over here? Because I'm not remembering any of this. Would you like to tell me at any point about it? No, you wouldn't? Okay, that's great. The defendant thus invoked the judicial power to seek a remedy, and trial court exercises power to adjudicate. The public can thus now be permitted to exercise its right of oversight and inform its own view as to whether the police acted appropriately or inappropriately in Mr. Recada's case. Citing Nixon v. Warner commute, what the fuck? In short, the trial court erred here in two fundamental ways. First, it purported to determine the records at issue in this case were not judicial records at all because they were not received into evidence, which they weren't, despite they were submitted by the relevant system, which, whatever. But once filed, records in connection with the motion are presumptively public and cannot simply be unfiled or removed. The trial court should therefore apply the six-part Hubbard factors, why, to the presumption of access. The trial court did not do so, but the six factors weigh in favor of access. Not really. This court should therefore review and hold and reverse, blah, blah, blah. Alternatively, Mr. Hardin was entitled to be heard. Why? Why was Mr. Hardin entitled to be to be heard? What difference would it have made? What difference would it have made? Mr. Hardin was initially granted access to judicial records, but access was suddenly revoked without notice or an opportunity to be heard. Then when Mr. Hardin took upon himself to file a formal motion to intervene and present evidence as to why the issues were properly public, the trial court purportedly granted limited intervention by again denying Mr. Hardin any opportunity to be heard. Well, I suppose it read your pleading, and there was that. Instead, the trial court made numerous findings of fact which were adverse to Mr. Hardin, all without allowing him to challenge the factual findings. Were they wrong? Did the trial court make a wrong finding? What are we talking about? This would be error in any event. No, it wouldn't. But doubly erroneous insofar as the court had recognized him as a party. Limited at that. Parties before the court necessarily must be heard and presented to give evidence. That is separate and independent ground for reversal, not unless it makes a difference. What difference would it have made? What testimony or evidence would you have offered? What error did the court make in its findings? Why does any of this matter? Allowing the intervention of a non-party in a lawsuit has significant implications. You know, by the way, while I'm thinking about it, I want to make a couple changes to my audio. So if you would just bear with me for just a second, I'm going to fix something real fast because I want to make some minor improvements to my audio. Talk amongst yourselves. How are y'all doing, by the way? You doing good? We can talk about other things. Okay, let's see. Noise gate is on, de-reverb is on, de-click is on. I need to enhance that or something. I think I need to increase the sensitivity of this a little bit. Let's increase it to 3.5. That's good. All right, let's try that. Low latency. All right, that's good. Frequency skew, click whining. All right, and okay, that looks good. Let's try that. All right, let's put on de-reverb. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. Great, that will change those settings, so that'll be a little bit cleaner. And the noise gate, do I even want to have a noise gate? Let's try getting rid of the noise gate completely and see if that does anything for me. All right, let's give that a shot. Sounds a little echoey. Well, hopefully it's less echoey now. All right, great. Let's give that a shot. Okay. Allowing the intervention of a non-party in a lawsuit has significant implications because an intervener essentially has the same rights as parties. Well, it depends on the nature of the intervention then. Here, Mr. Harn specifically requested limited intervention while trial court purported to grant for the sole purpose of concerning access to the records. Yeah, the de-echo thing is not going to be perfect. It just tries to make it less obvious. It's not the same thing as treating the room. It's just trying to make it better so it's less echoey. It's pretty good though. I mean, it's pretty good. It's pretty sophisticated. It's just not perfect. It's pretty good for software. Here, Mr. Harn specifically requested limited intervention where the trial court purported to grant for the sole purpose of concerning issued access records. But even in the limited context of intervention, Mr. Harn made plain that he was requesting two specific forms of relief. First, they permitted to file a brief, and second, he permitted to add evidence. Like what? The trial court effectively denied Mr. Harn's right to present evidence and be heard. You know what mistake kind of happened earlier today, incidentally? I don't know why this happened, but I was scrolling YouTube as I do, and there was a clip from Alyssa Clips with Nick Rekieta, and I mean, I don't know, man. I don't feel the need to address anything he says because he seems to do a pretty good job every single time, to my mind, basically showing everything he says to be crap. There's nothing for me to do. It's I just let the man speak and he takes care of it for me. It's sad in its own way. Yeah. A district court abuses discretion by making findings of fact that are unsupported by evidence, misapplying the law, or delivering a decision that's against logic and facts. Here, the trial court erred precisely because it made findings of fact without affording a party to be presented. It's not going to work unless you tell me why it matters. If this court does not outright reverse and grant access, should a minimum remand so Mr. Harn can present evidence? Like what? Specifically, Mr. Harn proffers here he would have presented evidence. The material filed MNDS was received into evidence, and transcript does not reflect the evidence was withdrawn. Well, you can just tell us about that now. You can just tell us. Additionally, Mr. Harn would have presented evidence that members of the public do not did access, and therefore conclusion. This was actually written by an attorney from North Dakota. How? How is it? I suppose the North Dakota attorney got pro hoc, I guess. How is this? This is a horrible brief. This is really, really bad. This is a horrible brief. This brief makes me sad. All right. Here was the right way to do this brief. Assuming the only way I can think to do this brief. Okay. Assuming you have the cards, which I know you don't have. So like, how would I write this brief? How would I write this brief knowing what I have to work with? I mean, you're just going to have to somehow try to sell it on the idea that there's public interest in it. That's what you're going to have to do. You're going to have to try to sell that this is a public interest thing. And you're going to have to try to use the relatively high profile nature of it, along with the scandal and coverage of it, as showing the public interest in it. That's what you're going to have to show. You're going to have to show that the public's desire to understand this material and want this material is the public interest in the material itself. You're going to have to try to sell that. I don't know if you can sell that or not. It's not public interest in the normal way we think about it. You know, it's not a police shooting that we need to see how the shooting occurred. It's not, a suspect being beaten up. So that's it's a run of the mill, average, ordinary drug search. It is, presumably, no one has said anything to the contrary. Presumably, it is a paint by the numbers drug search. It happens every single day. There's nothing particularly extraordinary about it in any respect. You know, the police may or may not have violated April's Miranda rights is the only interesting thing about it. And even then, it's like, okay, if they violated her rights, which by the way isn't at all obvious. It isn't necessarily obvious they violated her rights. So we don't even know because that issue never got adjudicated. There was never a hearing that determined whether her rights were in fact violated. We never got that far. But even assuming that they were, that's not particularly, extraordinary either. The police might have made a mistake. It's, there's nothing exceptional about this. This is not a public interest case. So the only thing you can do is try to sell them on the popularity of it and the public interest in the knowledge as being the public interest, and try to sell them on that. That's the only way you can go. The only way I can see. So none of this makes any sense. All right, let's read the state of Minnesota's brief, which I'm sure will be much better, by the county attorney. A much shorter table of authorities too, which is cute. Table of authorities is very short. Okay, then they go through a little bit of a procedural history of the case. All right. So let's see what happened here. Okay, let's see if we can get on some of the timeline that happened that matters. Okay, charged with one count, omnibus. Okay, exhibits were received, Franks, plea hearing, adjudication, hard and receptive copies. They've been uploaded by defense counsel and marked as admitted, which I don't think they were. Observing the footage was marked as admitted, but restricting their view only to courthouse by appointment. State filed a motion, request district court issue were correct, that they were never offered as exhibits, which I don't believe they were. District court granted the state's issue, that they were not accepted, which I believe is true. The footage of the body camera had been placed by defense to support the third omnibus issue relating to a possible motion limine. Both parties agreed their intent was not to offer the body cam footage marked as received. Therefore, it was meant to mark that it was not accepted, which, yeah. Filed a motion to intervene, blah, 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 blah. Okay. The district court issued an order denying Hardin's motion to access two body camera footage. The district court rescinded that order, granting limited access that stated while uploading the footage from the two body cameras, the status box was mistakenly checked to indicate the exhibits were admitted, which they weren't. It was a mistake. They were never offered as exhibits and they were never admitted. That was a mistake. The admitted status of the two exhibits was inaccurate and required correction. Yeah, that's true. That was a mistake. Yeah, that's right. Facts. In May 2024, information came to the attention of the Candiac County Sheriff's Office that Nicholas Requeta was in possession of controlled substance. He sure was. He was also in possession of a woman that didn't belong to him, and at the time belonged to another man. On May the 23rd, 2024, at approximately 9:13, the search warrant was executed at Requeta residence located in Candiac County. A search occurred with two deputies operating body cam. The videos are at the heart of the dispute. Candiac County Sheriff's Office discovered cocaine during the search of the residence, and Requeta was charged by complaint with possession of controlled substance. The Minnesota Digital Exhibit System is a newer process to streamline exhibit management, providing a secure and standardized means for submitting, accessing, and managing exhibits. MNDES requires party to upload and exchange proposed exhibits before a hearing. MNDSS has improved efficiency and remote access, but has introduced challenges. On August the 18th of 2024, Requeta's attorney filed an omnibus motion asking the court to suppress all evidence collected and derived from the unlawful search and seizure, hold that the warrant was not supported by probable cause, that the Requeta's arrest was unlawful, and suppress any statements made by Requeta subsequent to arrest, suppress any statements made by April, the whore, Imolte, subsequent to her Miranda invocation, and consequently dismiss counts 1, 2, and 3. With the motion, the defense attorney submitted a pre-omnibus argument. Additionally, he uploaded onto MNDES multiple times, including application for search warrant, Requeta video, PowerPoint, KCSO supplement, Requeta picture, letter from KCHHS, recording of the Steel Toe Morning Show, Holla, Detective Pomplin's body cam footage from the search warrant execution, and Detective Sergeant Brandis's body cam footage from the search warrant execution. On April the 21st of 2024, the omnibus hearing was held. The court asked defense attorney what the issues were. When the issue of Mrs. Inholte's statement, otherwise known as the whore, was reached, the district attorney interrupted and stated it appeared to be a motion in limine to discuss that the case was set for trial. It was. It's like, yeah, it was way premature. Yeah, Nick Requeta bringing it up when he did was way premature. It's a motion in limine. The trial court was correct to note it's a motion in limine. That's an issue way down the road. Way down the road. And it's not for now, man. And this has nothing to do with anything. Yeah. Someone said, can I not be a disrespectful pig? Well, you can put a dress on it, but a pig is still a pig. It's like, I mean, that's a dumb comment. Would you prefer I call her a vacuous free use slut? I mean, I could do that instead if that's more of a nomenclature. Although she did use cocaine, so arguably she was being paid in cocaine, or she was paying in cocaine. I don't know. It could have been a lot of things, but I don't think me being disrespectful is the problem here. I really don't. Also, she's a disrespected person, so fuck her. Or I would have, but Nick Requeta took care of that for me. To be honest, so I think she's got that covered. Defense attorney, after expressing concerns about needing to raise the issue early enough, then know the state had conceded the issue. The conversation switched to discussion of the items placed in the MNDES. The court asked the defense attorney to detail what exhibits are. Maybe just use her name. No, I prefer whore or slut. No, I don't think sluts and whores don't get names. Yeah, no, yeah. They don't get names. Yeah, no, that's okay. Defense attorney responded, I'll get rid of the two easiest ones to get rid of. There are two body cam videos because the prosecutor is conceding that's not necessary and those relate solely to the third issue I raised. Those are not particularly relevant. Oh yeah, no, Nick Rekieta's wife was also doing all that stuff too. So if you want to say that about Nick Rekieta's wife, that's true too. I'm just talking about April right now, but yeah, I mean they all were breaking vows, and yeah. So yeah, all those things. Yeah. Yep. On September 24th, 2024, Judge Wenzel issued an omnibus order. On the first two pages of the omnibus order, the court specifically exhibited the exhibits. And I suppose also Nick Rekieta is also a slut, and also Steel Toe is also a slut. They're all sluts and whores. Yeah. So, but I need a way to distinguish them if I'm going to not refer to any of them by name. Because if I call them all sluts and whores, it's going to get confusing who I'm talking about. I'll figure it out. The court stated at the hearing the defendant offered and the court received without objection Exhibit 1, application for a search warrant, Exhibit 2, Exhibit 3, supplemental report, Exhibit 4, Exhibit 5, letter from KCHHS. Defendant offered and state objected to Exhibit 6, recording the Steel Toe show. The court took admissibility of Exhibit 6 under advisement. After review, the court determined Exhibit 6 is admissible as an offer of proof. The body cam videos are clearly not listed as, well, we could call one DS9 whore. We got DS9 whore, blonde whore, steel whore, and coke whore. Is that unambiguous enough? We could try that. Well, we'll give that a try. See how that goes. The issue of blonde whore statement was not addressed in the order. On January 24, 2025, Coke whore entered guilty to a felony drug possession charge and was sentenced on April 18th of 2025. On April 22nd, 2025, the appellant requested from court access to the court camera video submitted a Minnesota Judicial Branch copy request form. On May the 1st of 2025, the court granted an appellant's request, observing that they're marked as admitted but restricted interviewing only at the courthouse by appointment. On May the 29th of 2025, the state filed a motion to correct court records in the criminal file to indicate that two body camera videos were never offered nor received as exhibits in the omnibus hearing. On May the 30th of 2025, after receiving the transcript, the court granted the state's request to correct court records. Yeah. On May the 30th and June the 1st, after the court's order, the appellant filed the notice to motion to intervene for the purpose of asserting the right. The appellant sought to intervene to consider briefing. The appellant filed this up with supplemental authority. Concubine whore. Yeah, wife whore and concubine whore. Maybe that's the way to go. The case involves an attempt by the appellant to obtain data in the form of two body camera footage not offered into evidence into any court hearing. The law is clear. Appellant has no right to this data and wants to take advantage of an error by the court administration in labeling the data submitted through the new process. The court should deny. A district court's decision to restrict access to court documents is reviewed for abuse of discretion. District court findings of fact are reviewed for clear error. In applying the clear error standard, appellate courts view the light and evidence most favorable to findings. Appellate courts will not conclude that fact finder clearly erred unless on the entire evidence they are left with a definite firm conviction the mistake has been committed. When record reasonably supports the findings at issue in appeal, it's immaterial the record must also provide a reasonable basis for inferences and finding the contrary. Uploads in MNDES but not offered or received are not case records. Whether the body cam videos are publicly available depends on the data is received as evidence. To understand the question, one must understand the MNDES process and a review of what occurred at the hearing. The Minnesota court system has switched to a process where potential exhibits are entered electronically. In this case, Rekieta's attorney filed an omnibus motion making various challenges to state evidence. One such issue relayed was evidence of co-defendant statements, which were recorded on two body cam footage of two deputies involved in execution of the search warrant. However, when the omnibus hearing was held, Rekieta's attorney indicated this was no longer an issue as the prosecutor conceded, which she did because she would have, right? I mean, it's an issue of confrontation clause. Unless they put April on the stand, they can't use the statements against him because it's, because it's a confrontation clause issue. When the court asked which items upload to MNDS were being offered to evidence, Ricke's attorney statement is getting rid of the 2 body camera videos as they is no longer relevant. If there remained any doubt or confusion about what exhibits were offered and received, the district court clearly offered and received it in its order. Statement does not include the 2 body camera videos, demonstrating the body cam videos were not exhibits. Further review of the omnibus order demonstrates the issue of co-defendant statement. The issue originally identified by Ricke's attorney as being the issue the body cameras would be relevant on was not an issue the court resolved or addressed. It did, because it's like, this is premature. The court was correct. There was no reason to address it at that time. The court's like, this sounds suspiciously like a motion to eliminate. This is way down the pipe. It's way early for this. Yeah. The body cam videos were not evidence offered and received. The district court found as much. The issue thus turns to the nature of the MNDS upload. The applicant claims plainly a judicial record. The claim relies primarily on opinions outside Minnesota, and not from this circuit at that. But the Minnesota Supreme Court has ordered otherwise. Well, that's pretty fucking good authority. You know, who has a pretty good authority about what is or is not a Minnesota court record? You know who'd be a really fucking good authority as to what is or is not a Minnesota court record? The Minnesota Supreme Court would be a really fucking good authority. So if the Minnesota Supreme Court says it's not a court record, guess what? It's not a court record. That's how that works. That's how it works. By an order of August 30th, 2024, entitled Order Regarding Use of Minnesota Digital Exhibit System in Minnesota District and Appellate Court, signed by the Chief Justice, the Supreme Court stated, exhibits in MNDS offered in court proceedings are case records as defined by Rule 3. Exhibits uploaded and stored in MNDS but not offered to the court are not case records and are not publicly accessible. Well, that sort of clears that the fuck right up. I mean, that issue's like over. I mean, the Minnesota Supreme Court says that if they're not offered and they're not publicly available. So that really solves that issue right the fuck up. It's like we can probably stop reading at this point because everything else is futile. As the 2 body camera videos were not offered or received, the Supreme Court clearly identifies as not publicly accessible. That's pretty good authority. The District Court likewise concludes the uploads not offered in evidence are not publicly accessible. This conclusion was based Minnesota Supreme Court and U.S. Supreme Court case law. District Court said the Minnesota Supreme Court has held private documents generated during discovery and not filed with the court are not subject to public access. This principle supports the notion that exhibits not admitted in evidence do not become part of the public record. Restraints placed on discovered but not yet admit evidence are not a restriction on traditional sorts of information. For an exhibit to become part of the judicial record and therefore accessible, it must be admitted or used in the proceeding. Well, that sounds fucking right to me, right? Unless it's actually used in the proceeding, it doesn't count. That sounds correct. The applicant seeks to circumvent this determination by relying on errors made by the court administrator incorrectly identifying the data as admitted and allowing others to access based on the error, or the district court in saying it was public based on the same error. But these circumstances are not situations, the court made a mistake. Even if the court said all those things, the court made a mistake. It's not bound by those mistakes forever, right? If the district court made a mistake, it made a mistake. So, it corrected the mistake, which you want courts to do. You want courts to make the mistake. You want them to correct mistakes. If I ever become a judge, you better bet your ass I'm going to make mistakes. I'm a human being. All I can hope for myself is that I'm wise enough to fix my mistakes. You know what's going to happen. I'm going to blow some calls, potentially important calls. I'm a human being. I'm going to make mistakes too. I know I will. I'll do my best. Hopefully I'll fix them. The district court did not abuse discretion in its decision to restrict access to the uploads not offered or received evidence and process on this decision. The appellant asserts a right to intervene with citation to Rule 24. But as the district court noted in the order of the motion to intervene, April remarried? Well, I don't care whether or not she remarried or not. Also, if I were her new husband, What's the saying? You can't shake the whore tree and expect a wife to fall out. Good luck to you, sir. Whoever you are out there, Godspeed. Did Kurt drop 10 pounds? Hopefully. Kurt has been exercising a lot. Kurt, why am I talking about myself in the third person now? I've been going to the gym a lot. I've been going to the gym quite a lot. I've taken up powerlifting. It's going really well for me, by the way. I'm hoping to hit 3 plates for my big 3 lifts on my birthday, January 13th. I'm basically there on squat and deadlift, and I've got about 20 pounds or so to go on bench. But it's going really well. I was at the gym today. Today we were doing some belt squat, and we did some dumbbell RDL, and we did some landmine twists, and we did a 1-leg leg press in lieu of lunges. It was great. I am not Aquarius. I'm Capricorn. Don't disrespect. While a Minnesota authority directly addresses a right to intervene in a criminal case, the district court exercises discretion and allowed limited intervention because highly potentially criminal. I'm glad to have you here. Because I don't mind the diversion. We can talk about the gym. It's great. I did a 90% lockout on a 335 deadlift yesterday, or was it the day before? It might have been yesterday. I'm not 100% sure at this point. It was yesterday or the day before. Which was more than I intended to lift. I miscalculated the amount of weight. So I put too much weight on it. But I did a I did like a 90% lockout on a 335 deadlift, which was exciting. This is all great news. It's all fantastic. Everything's coming up Uncivil, man. Let's see. While no Minnesota authority directly addresses right to intervene in a criminal case, the district court exercised discretion and allowed limited intervention because the purpose was determine access and review of outside jurisdiction, shown in a number of jurisdictions allowed intervention in criminal cases for a limited purpose of access records. Would you like to see my lift attempt where I came 90%? Would you let's see if I can pull it up. Hold on, change the audio source so you can hear this, I guess, for whatever value the audio has in this thing. So you see it's a 45 plate, and then it's 4 25s on each side, in case you're wondering what that is. So that's 335. So that's what that is. Because the 25-pound plates are smaller than the 45-pound plates, and therefore much easier to put on and take off. So it has too much weight because I was lazy. That's what's happening right here in this shot. Okay, pressing on. That's close, ma'am. That was close. So close. Damn. You can taste it. Taste it. Shit. Next time. Next time. All right, where was I? Let's see. The appellant also claimed, thank you, Tall Skinny Geek, that's appreciated. The appellant also claims that he should have been allowed to submit briefing and present evidence, but the appellant did not submit legal argument authority with his motion. The court found the issue to have been fully briefed. No rule requires a set procedure for the courts to use in such situation where the data sought is not actually a case record publicly available. Judicial power encompasses inherent authority to control the performance of judicial functions, which includes control of court records. We could also view my recent squat at 3:15 that I actually did succeed on. I already posted this one though. So some of you guys may have seen it, but we could post. Let's see if I can find my squat that I actually did recently. Is this three dumbbell squat? I think this is the right one. Yeah, we're gonna 3-plate this squat. Oh yeah, let's go, baby. Let's three wheel this bitch. Let's go. Come on. Yeah. Yeah. Yeah, kick ass. Yeah. No rule requires a set procedure for the court to use in situations where data sought is not actually a case recorded publicly accessible. Judicial power encompasses inherent authority to control the performance of judicial functions, which includes the control of court records and agents of the court. Here, the district court allowed the intervention to decide the data access issue. It heard and considered the appellant's arguments and authority. It decided no additional process needed as the data is not publicly accessible. You can still hear audio. Yeah, sorry about that. No worries, I'll get that. Sorry, my bad. Thanks for letting me know. Yeah, thanks for letting me know. Decision-making was well-reasoned. It balanced the importance of determining whether data is available with criminal rules that do not specifically allow for any type of review. The appellant said he was looking for access to the body cam footage. Whether access exists based on the issues noted or whether the district court received the body cam footage and the evidence and nature of the state, the district court, in fact, made this review. The appellant's alternative relief should be denied. Yeah, that all makes sense. Yeah, the grunting added to the atmosphere. Yeah, shows context is everything. Yeah. So yeah, so that was the 315 deadlift, a 315 squat, and then we did that 335 deadlift I showed you, and our last PR on bench was like 270 or 275 times 3 or something like that. It works out to like 300, 305. So the bench is still a little short. But I will 3-plate this bitch by my birthday. I will 3-plate this bitch, and then I'm gonna 4-plate this bitch. That 4-plate bench, I must have it. I must have my 405 bench. So we will get there. I only have to pick up another 110 pounds. You know how hard is that? Yeah. All right, and so that's the end of that thing. And then we will read Nick Rekieta's brief for all of its glory. I'm enjoying going to the gym. I've become a regular now. I'm fist bumping people and doing the bro nod and the whole thing, man. I've annexed a cubby at the gym and not told anybody, so I can keep my stuff there. All right, legal issues. Is appellant Mr. Hart entitled to review records uploaded by respondent Nicholas Rekieta into MNDES and cited in a memorandum of law filed with the district court? pursuant to the Constitution and common law right of access. These issues were raised in the plea, and district court ruled that intervener was not entitled to review or access upload that's been offered evidence. The issue was preserved for appeal by order entered. His appellant, Mr. Harden, as an intervener in criminal matter, entitled to be heard and present evidence. This issue was raised in plea, and district court ruled the intervener was not entitled to oral argument nor evidentiary hearing, which, by the way, he never said what evidence he would have offered that would have made any difference. Well, district court issued an order denying appellant Harden's motion to access the two body cam videos. The district court thereby vacated its order, granting limited access to two body camera videos. The district court found that when court administration marked up the upload footage, the status box was mistakenly checked to indicate they were exhibit admitted, but they were not. The administrative error of these two exhibits was inaccurate, required the district court to correct and prohibit access of non-public documents. This appeal failed. Yeah. I should wear Snap-on gloves to lift. That'd be good. That'd be funny. Yeah, get myself some Snap-on gloves. On May the 23rd, 2024, at approximately 9:13, a search warrant was executed at a residence in Candido, Ohio County, at a residence. Notice this is Nick's brief, by the way, but he says a residence. You mean your residence? By two deputies wearing functional body camera equipment which record the search. The resulting video at the heart of this dispute, as respondent Nicholas Ricada filed a motion to suppress their usage in the resulting criminal proceeding. Digital copies of these body camera videos were uploaded into the Minnesota Digital Exhibit System in support of the motion. MNDES's new computerized information system designed to streamline exhibit management, providing secure and standardized means for submitting, accessing, and managing exhibits. MNDES requires parties to upload and share proposed exhibits before hearing. MNDES has approved efficiency, but introduced challenges. On August 18th of 2024, Nicholas Ricada filed an omnibus motion asking for a whole bunch of things. Accompanying the motion, he uploaded MNDS, the application for the search warrant, a Ricada video PowerPoint presentation, a supplement, a picture, a letter, a recording of the Steel Calm Morning Show, and some body cam footage. At the August 21st, 2024 omnibus hearing, the district court asked defense attorneys what the issues were. When this issue of, what are we calling her now? What was our latest version of this? The succubus's statements were reached. The district court interrupted and stated it appeared to have been more of a motion limine, discussed that the case were submitted for trial. Defense attorney, after expressing concerns about needing to raise the early issue enough, then noted the state had conceded the issue. The conversation switched to discussion of the upload. The court asked defense attorney to detail what exhibits are. Defense attorney responded, I'll get rid of the two easiest ones to get rid of. Those are the two body cam videos because prosecutors can see they're not necessary and those relate solely to the third issue I raised. Those are not relevant. Discussion continued on what items were being relied on. The download items identified as defense exhibits were the Steel Tone Morning Show, the search warrant, the letter, the PowerPoint presentation, the supplement, and the screenshot. On September 21st, the judge issued an omnibus order stating what things they considered. The body cam footage is not listed as being received into evidence. A review of the omnibus order shows the court did not consider the body cams whatsoever. The issue of the wenches statements were not addressed in the order. On April the 22nd of 2025, appellant requested from the district court access to two body cam footage submitted by the Minnesota Judicial Branch copy request form. On May the 1st, 2025, the court granted appellant's request, observing that they were marked as admitted, but restricting their viewing only as courthouse by appointment. On May the 29th of 2025, the state filed a motion to correct court records and criminal file to indicate that two body cam footage were never offered nor received as exhibits by the omnibus. On May the 30th, after reviewing transcript, the court granted the motion. On May 30th and June 1st, after the court's order, applicant filed a motion seeking to intervene for the purpose of preserving the right of access. Applicant also sought to intervene to consider his briefing on whether the two body camera footage were publicly available. The appellant followed up with supplemental authority. Respondent, Nicholas Ricada, submitted a memorandum in law stating Minnesota's position the body cam footage was not public record and the court had the right and responsibility to correct administrative records. Yep, all those things. Standard review. A district court's decision to restrict access is reviewed for abuse of discretion. District court's finding of fact are reviewed under clear error. Upload to MNDS but not offered or received an exhibit are not case records. Whether the body cam footage are publicly available depends on whether data was received. To understand the question, must understand. This is the same brief the government filed. This is Nick Ricada's brief, right? This is like almost verbatim the same. It is the same. Well, it's his brief, but it's almost word for word. Did they just plagiarize, or did they write together, or what? It's like almost word for word the same. Okay, does he have anything new to say on this issue? Let's see. Getting rid of, confusion, blah, 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 blah. Judicial record applies primarily opinions for foreign jurisdictions. They're determined otherwise. Yeah, it's like did he just plagiarize the government's brief? I mean, it's almost exactly the same. Why didn't he just file a joint brief? He could have just filed a joint brief. Why did he take the time to file almost the same thing verbatim? Or I don't get it. Okay. Did he copy them or did he write theirs? I'm gonna go with it was this. I'm gonna go with it was the state of Minnesota that wrote it. Between the possibility that it was Nick that wrote it and the state that wrote it, I'm gonna say it's the state that wrote it. Yeah, I'm gonna say that they are the one that did the heavy lifting on this one. Yeah, and that's what I'm going with. As two body camera footage were never offered nor received, the Minnesota Supreme Court clearly identifies upload MNDS is not publicly available, according to this court said, blah, 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 relying on foreign authority, blah, blah, blah. The body cam footage were never properly filed, blah, blah, blah. Yeah, Hilbert is not binding on the Minnesota District Court, no shit. Persuasive authority for the District Court of Minnesota. It never adopted the test. This court should reject such authority. Yep. District Court did not abuse discretion. Cites a foreign case, foreign law. Yep. The brief sucks. The appellant asserts a right to intervene in an underlying criminal case. Is it too late to file an amicus in this thing that they've had oral argument? First of all, I need a Minnesota attorney to file it for me. But if I write an amicus, you think it would help? It can't hurt at this point. I'm not sure anything can save this appeal at this point. But I could try. Does anyone happen to know an attorney in Minnesota who would let me file or sponsor me for pro hoc, or so I can file a brief? Reach out to Hardin. Well, Hardin's lawyer himself is pro hoc. He can't do it. Yeah, Hardin's lawyer can't do it because he himself is pro hoc. He can't sponsor me. So, Bruce Rivers? Address rights also claims to submit briefing. No rule near criminal requires pre-set situations. Blah, blah, blah. Blah, blah, blah. Yeah, okay, great. So, all that stuff. Yeah. So, yeah, Nick Rekieta is right, and he will almost certainly win. Because he's correct. He's correct on the procedural grounds, and the argument to have the footage released is the wrong argument. I don't know whether or not the right argument could have won, but this argument can't win. This argument is based off of a checkbox that was checked that was a mistake. And when the court realized it was a mistake, they unchecked the box and sealed everything again because it shouldn't have been released in the first place. So this argument doesn't go anywhere. This argument is dumb, and it should feel dumb. So Nick is going to win this argument easily. He's going to win it easily. I don't know if you could have won another argument. The only argument you could win would be you'd have to go in. Well, you'd have to go in through a public records request. Is the only way to do this. You'd have to do this. You'd have to file a public records request. And then when you're inevitably denied, which you will be, you'd have to sue on the basis that your public records request is in the public interest, citing the internet reviews and cases that have been discussed and the videos that have been made and discussions that have been made. That's the only way to do this. And I don't know whether or not that would work, because the fact that the public wants to know isn't quite the same as public interest. Right? Public interest normally means it's more in the vein of like an officer involved shooting or an officer beat up a suspect, or more in the vein of like, not based on its popularity, but based on like the egregiousness of its violation of the civil order, right? It's not based on whether or not people want to know about it. It's based on whether or not they need to know about it, I suppose, is a better way of viewing it. So that's the better way of looking at public interest. So you're basically wanting to use popularity to overcome all that. And I don't know if that would work. But that's your only line of argument. And incidentally, by the way, you could still do that, because this decision won't prevent that, because this decision is coming at it from a completely different viewpoint. So the only way to try to get access to the body cam footage at this point would be to request the public record, be denied, sue, lose, and then appeal and hope for the best. And that's it. Are there controlling cases on body cam access? I'm sure there are, relative to public interest. So you'd have to go dig into the case law to find what authority there is when it comes to public interest, and try to find cases that are analogous to this case. You'd want to find cases where it was deemed to be public interest that could be in some sense be of the same kind, to use that as a foothold. So yeah, I'm sure there are cases that are on point. I don't know what they are because I haven't done the research. The cases that are on point probably mostly relate to the more egregious stuff, right? They relate to the shootings and the beatings and that kind of thing, right? Those are the cases that are probably out there defining the public interest. Cases that would allow this situation to be in the public interest, there might be a case out there. It might exist, but you have to go find it and hope it exists. Or otherwise, you're going to have to try to, and if it doesn't exist, you're going to have to try to use whatever authority you can cobble together from any other jurisdiction you can find, and try to bridge the gap. And I don't know whether or not you could pull that off or not. I don't know if you could pull it off. You could, but that's the only path I can see. That's the way I would run it. And I don't know if that would work in the end or not. But that's what I got. Yeah, allegations of policeman conduct seem like the ones that would spawn cases. Yeah. So, you're not going to be able to get there on the U.S. Constitution. You're not going to be able to get there on federal authority. You're not going to be able to get there that way. You're going to have to get there on Minnesota law. Maybe bring the other jurisdictions in for some sort of persuasive effect, but you're going to have to convince the courts that this is the right thing for Minnesota. And the legislature statute is going to be a huge inhibitor. So, yeah. But that's the path I can see forward. So, but this appeal will be denied, I'm sure. All right, well, I hope you enjoyed that for whatever value it has. Yeah. Minnesota's safety is based in Minnesota. They say Minnesota's a pain, but you have to jump through hoops. It might be possible. But this situation doesn't seem like it lends itself to the typical. When you think about the typical police body cam, the kinds that just ask yourself, what are the kind of videos that you normally see from places like Midwest Safety? Like, what kind of videos do you see? Right? And the videos I'm describing are the videos you see, police interaction gone wrong, police shooting gone wrong, police beating gone wrong, police misconduct, that kind of thing. So, right? So, yeah, it can be done, but can it be done in this fact pattern? I don't know. That's tougher. All right, guys, I'm going to sign off for now. We'll see how it goes. And they're generally in public areas. That too. Yeah, that too. So that goes a long way. I'm going to sign off for now. I hope you've enjoyed this content. Make sure to hit the like button. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye. And let's all go lift something together. Let's all go try to work on that bench press together. Let's all see if we can crush those bench goals, man. Woo. Later, bye.